My name is Reuben Tyler. I'm a New Zealand barrister and I'm a director and shareholder of Trustees and Fiduciaries Cook Islands Limited. Today I'm going to talk about Trustees and Fiduciaries' new trust product, the Relationship Property Trust. The Relationship Property Trust Act was developed by Trustees and Fiduciaries in conjunction with US legal advisors. It is innovative and unique legislation. It creates a new class of international trust, which is a Relationship Property Trust, or RPT. The RPT is designed to address serious mischief in matrimonial property. In my 40 years as a professional trustee, I've seen trusts set up by high net worth families achieve careful growth of assets, transfer wealth and management across generations, and provide financial security for future generations. But I've also seen these carefully planned and administered trusts destroyed by the divorce of the settlor spouses. In recent years, matrimonial courts have adopted two new legal doctrines that relate to matrimonial property. The first of those doctrines is quite simply that trust property is now often included in the pool of matrimonial property that they are investigating. The second is that all matrimonial property should be divided and distributed. The consequences that I've seen following the divorce of the settlor spouses are significant. They include the fire sale of assets under pressure from courts, the distribution to spouses who often have no financial expertise and are then exposed to gold diggers. The interests of children, grandchildren and future generations are ignored. Family businesses in particular are vulnerable to being broken up. And of course, attorney contingency fees tend to reduce the value of the asset significantly. The consequence of these new doctrines is that a divorce can destroy the fundamental purpose of establishing a trust. And this is the mischief that the Relationship Property Trust Act addresses. Because of this problem, I decided to research other planning techniques to see how I might achieve the primary objective of keeping trust assets intact. I researched the law in a number of jurisdictions. I met with many specialist trust and matrimonial property lawyers. But what I found is that while most countries have general acceptance of the right for parties to make their own arrangements, that acceptance doesn't extend to matrimonial property. The two most common planning techniques were prenups and trusts. Prenups are approved of in principle by the courts, and in practice their use is limited by common sense doctrines which require independent representation of both parties and full disclosure to both parties. But the courts also look at fairness of the arrangement as at the date of separation as opposed to the date of the agreement itself. And it is implicit with a prenup that the prenup deals with division and distribution rather than keeping the trust assets intact. With trusts there are particular problems. The courts see potential for abuse where a trust is created by one settlor. There are no disclosure requirements and no independent representation of the other parties. There is also opportunity for a dominant settlor to influence management. The courts then have reacted negatively to trusts. Trust assets are now routinely included in the pool of matrimonial assets, and in practice the courts examine the fairness of administration, both in theory and practice, the fairness of arrangements at the time of separation, and they adopt the principle of dividing and distribution to trust assets. So I decided the only way to reverse this trend was to start afresh and design new legislation. In my opinion, we needed legislative authority that approved the parties making their own arrangements in the event of separation, that rebutted the principle required division and distribution of trust assets, that supported parties choosing to keep assets intact under common management after separation, and finally restricted the ability of foreign courts to interfere with this choice. So that is what the Act does that is different. The Act reverses the principles being applied by matrimonial courts elsewhere to trust assets. It also has special protection for trusts holding ownership of a family business. Where a family business is held by a trust, the mischief can be acute, and this is addressed by a special part of the Act. The Act provides, again, that the property is to be kept intact and not distributed. It can forbid any sale of the ownership of the business. It can provide for management by a controlling principal, and it does provide for close supervision of the business by the trustee after separation of the parties. Now, the question I'm asked often is, will a relationship property trust actually work? Because, of course, it's brand new. I think it's important to understand that the Act provides a framework only, and that ultimately its effectiveness will depend not just on the provisions of the Act, but also on the fact situations in each trust, on the terms of the trust document, and on the administration of the trust. Despite this, I anticipate acceptance of the concept by courts in the United States because the Act is not aggressive, it is protective of the rights of the parties, and it also promotes family values. Where trust assets are held in the US, the effectiveness of the relationship property trust will rely on recognition of that trust by US courts. If the trust assets are held outside of the US, then that recognition is not so important. Who might benefit from a relationship property trust? The obvious examples are high net worth married couples, couples in relationship property jurisdictions, couples not able to marry, family-owned businesses, international couples who have different domiciles and assets in different jurisdictions, and of course, second marriages.